I have a few slides for you, and I will address this topic, even though you heard a very, very authoritative opinion on the topic, so then you can make your own decision. So what is opting out and what is opting in? So first of all, some trivia. Opt-out is actually the term that is used in the law in the UPC agreement, which I find particularly effective. In Italian, it's not quite as effective because it's rinuncia, which sounds a little less sexy in my view. Opt-in is not the word that is used in the UPC agreement. The word that is used in the UPC agreement is the withdrawal of the opt-out, but we're all talking about opt-in because it's equally sexy. Not the opt-in itself, but the word. The opt-in itself is not sexy because, and now I'm Willem, you're never going to opt out anyway. So is it an action point? As Lydia correctly was saying, yes, it's something that now needs to be decided. If I'm Willem now, I'm going to say, there's nothing to be decided. You're not going to opt out. It is an action point. Why is it an action point? Because a lot of companies are thinking about it. You know, regardless of whether we think it's a good idea or it's not a good idea, clearly it's on people's mind. This is what everybody's talking about, so we need to talk about it today as well, evidently. The default position to remember, if you're a lazy patentee, for example, is that if you don't do anything, you've made the decision. If you don't do anything, you don't opt out, you're in the system. So the decision is whether you want to leave. If you don't do anything, you're in the system. So you don't have to take action to be in the system because the default position is going to be that you are in the new system. After all, this is the future. So of course, transitional provisions are there for a reason because at some point they go away and the future is there in full. Of course, in this case, the transition provisions are particularly long for opt-out. It's 7 years. So this is, I think, another reason why everybody's talking about this opt-out provision, because 7 years is a long time. So we'll talk about it today. So what can you opt out? This is another thing where we've seen a lot of confusion. A lot of people think that you can actually opt out unitary patents, which you can't. Or that when you, what was it that you told me, that when you opt in, you convert your European patent into a unitary patent. These are two completely different things. I will not bore you with it, but one is the patent and the other one is where you litigate, okay? The only thing you can opt out are European patents. Unitary patents, by definition, are within the new system, okay? You can also opt out patent applications, pending patent applications as long as they're published, which I find particularly interesting because, you know, this is really the possibility to make a very early decision, maybe sometimes too early a decision. God knows what will happen to your European patent application by the time it grants. But on European patents that have already granted, that's, you know, where a lot of people feel that they should be making a decision, and also for pharmaceuticals and agrochemicals. Remember that whatever you decide for your patents that bear SPCs, you are going to decide for the SPCs also, and vice versa. So you cannot opt out SPCs, supplementary protection certificates, but not the underlying patent. The whole thing just goes together. Like I said, no opt-out for unitary patents. SPCs are automatically opted out, like I said. Opt-out must be requested, and this is one of the more fascinating parts, I think, procedurally. May sound a little boring, but I'll address it anyway. It has to be requested for all states for which the European patent has been granted, or if you're requesting the opt-out for a European patent application, it has to be requested for all states designated in the European patent application. As a reminder, and this is where the US clients have told us literally, don't show us another map. We don't want to see. So I'm not going to show you maps, but believe me, the maps are very helpful. If you go to the site of the website of the European Patent Office, you'll find very nice maps. This is very important because what this means is, remember, European patent applications automatically, invariably designate 38, 39, I can't remember now, 38 countries, 38, way more than the European Union, way more than the countries that are now adhering to the unitary patent, okay? You have to opt out for all of them. Now you're going to say to me, why do I have to opt out for a country that it's not even covered? I will never be covered by the Unified Patent Court, such as Turkey. Turkey maybe at some point will be in the European Union. Switzerland, who will never join us. Why? Why? Because that's what the law says. Why is this important? Because in these countries, you may have different owners than the owners you have in the countries that are part of the European Union or the unitary patent, okay? All those owners have to agree. The opt-out has to be filed on behalf of all of them. Very important in practice. And also to make the opt-out valid. Opt-out automatically is deemed to be withdrawn if the European patent owner requests unitary effect. What I'm saying here is you have a published European application that published yesterday. Today you decide to opt out, Willem disagrees, you're making a stupid decision, you decide to opt out. In 2 years, the European patent finally grants you a patent, and at that particular stage, you completely forget that you opted out back then, and you decide, you know what, this the unitary patent is really, really interesting. It's cheaper, there's no translations. Yes, I need a translation, I can use a machine translation. Renewal fees are lower. You know what, I'm going to get the unitary patent for the countries that are covered by it. Automatically, you're giving up the opt-out. So in a way, it makes your life easier because you don't have to remember to opt in again. At the same time, remember that you may have decided things in the past that you may be reversing with your actions. Duration of the opt-out option, as we know, 7 years. So during these 7 years, we heard what Sabine was saying about what you can do. The patent owner can opt out, or the patent owner can opt in again. One thing to remember is you cannot opt out, opt in, opt out, opt in. You have to make up your mind. Literally, this is what the law says, meaning if you've opted out once, you cannot do it again. So once you opt in again, meaning you return home to the UPC, that's where you are, and that's where you stay.
You can remake the same wife only once.
Exactly, exactly. Make up your mind. And if the opt-out is not withdrawn, it remains valid for the entirety of the lifetime of the European patent. What this means is that if I have a patent that was filed yesterday, so 2023, it will live, if I pay the renewal fees, until 2043, and if I opted out, it will remain opted out until 2043, even though in 7 years, it will not be possible to opt out anymore. Okay, so the 7 years are only for actually opting out, not for when the opt-out is valid. When can you opt out? So we all heard about this fantastic sunrise period. So you can start opting out on March 1st. Then you can opt out again, if not for the same patent, of course. But the idea is once the UPC starts operating, you can opt out, but you can opt out already on March 1st. Why? Because this way, well, I think the UPC is hoping that there will be an opt-out, no opt-out, so they will not be flooded by opt-outs, but of course they want to be sort of prepared for the impact. So this is my personal opinion, I imagine. The idea of the sunrise period is so that if a lot of people are going to opt out, the UPC is not overwhelmed by all these requests coming all at once. For all of those of you who were there when the EU trademark was introduced, the day one of the existence of the EU trademark, there was a flood. I mean, it was fantastically successful, and there was a flooding of trademark applications, and the EU IPO, as it's called now, luckily, better name, was not prepared. So I think from the strictly, let's say, procedural managerial standpoint, having this possibility is a great idea. We'll see how many people will opt out. Of course, I don't have any statistics because we're not yet on March 1st, so we don't know. We don't know what's going to happen. It will be very interesting to watch. Pros of keeping the UPC jurisdiction. So this is the main question, right? So everybody understands what the opt-out is. The question is, should you do it? Willem says no. Why should you not do it? There are a lot of reasons, in fact, why you should not do it. The first reason is we were waiting for a single litigation. Finally, now have a single litigation. They give us a single litigation. We say, no, we don't want a single litigation. We're waiting for it. UPC certainly will issue very speedy decisions. If we all consider our experience in litigation throughout Europe, most countries don't issue a decision on the merits first instance in 1 year. So that's very good for business. Not for our business as professionals in the IP world, but for the actual business to have legal certainty. There will be technical judges, which I think will render this court particularly well-versed in patent matters. There will be the possibility of litigating in English, meaning, for example, now if you have a European patent and you go litigate in Germany, you have to litigate in German. If you go to France, you have to litigate in French, which is all very nice and good. I'm a big fan of many languages, but as my dad used to say, broken English is the most well-spoken language in the world. So don't you prefer a litigation in English where you can understand something? Probably, yes. With all respect for French and German, and many other languages. And, you know, for our Italian audience, of course, there's always the possibility of litigating in Italian at the Milan division, the local division. That's also very good news. Other factors for keeping the UPC jurisdiction are things you can ask yourself. So how really likely is it that the European patent is actually going to be involved in litigation? Now, I don't have statistics, I think, because it's just impossible to have them, of how many litigations are filed every year against European patents in the various UPC countries. But I can tell you that the number of oppositions filed against European patents at the EPO, if you want to think about an opposition as an invalidity action, so draw some conclusions from that, the number of European patents that are opposed at the EPO every year, the number of patents that are opposed where a third party says, I'm going to invalidate it at EPO, is less than 5% of the total number of patents granted by the EPO each year. Less than 5%. 95% of our clients' patents are just sitting there with no litigation ever. So this whole, you know, why are you so scared about litigation that is not going to happen anyway? First of all. Second of all, how many UPC countries will be affected? Where is the patent really still in force? Maybe European patent, because you stopped paying renewal fees, you were not really interested, is really not in force in all these countries. So you're not going to lose the patent in all the UPC states if you leave it in the jurisdiction of the UPC. And this is one of the main concerns that a lot of people have. I'm going to lose the patent in all countries. Do you really have the patent in all countries? Nowadays, nobody has it. Nobody. Not even the pharma companies in the glorious days, they used to validate their patents in all 38 countries and even more if there had been more. They don't do that anymore anyway. So, strategy is more sophisticated. Is there more one owner for the European patent? Now, this goes back to what I was saying before, the practical aspect. Because you have to file the opt-out request on behalf of all owners, and they have to be the real owners, mind you, not the owners that are on record, the real owners. So if I have a patent and I sold it to Lydia, Lydia has to file the opt-out request. Of course, Lydia can ask Maria, who's her trusted attorney, but Maria has to do it on behalf of Lydia, not on my behalf, because I'm not the owner anymore, even if nobody recorded this transfer anywhere. We know that this is the case, that she's now the owner. It has to be opted out in the name of Lydia. What if I have had, because I sold it, a European patent that designated 38 countries, and I had nothing better to do than sell every portion to a different person. So I have 38 owners. So poor Maria is thinking, this is really nice. I'm going to make a lot of money because each owner is going to have to pay me, except do I find them? Do they care? Do they answer my emails? One owner is in Turkey and still thinking, why are you asking me? I'm not in the European Union. This is a European Union thing. Why? I'm not going to answer. So poor Mary is stuck there. Nobody's paying her bills. And in addition, nobody can ask her, request the opt-out. Or she can, knowing she's not going to do the right thing because she's not going to request the opt-out in the name of all the real owners. And Maria's trying to do her best and has nice disclaimers in all her emails. But the thing is, the opt-out is not going to be valid. So, practical issue. What is the litigation budget of companies? Because sometimes, people are saying, oh, the litigating in the UPC is going to be so expensive compared to litigating in one country only. True. What is the litigation budget of the company? Maybe they have enough to litigate at the UPC. Sometimes they do. How used is the owner to actually litigating? Some companies are used to litigating. I know of a company in the pharma field, I'm not going to say who actually had a room in their manufacturing premises for, we have saisie description also in Italy, right, descrizione giudiziaria. They actually had a room only for the lawyers of the adverse party every time they were being subjected to a descrizione giudiziaria. They had like a dedicated meeting room for them. Clearly, these people were used to litigating. So they're not going to be scared by, litigating at another court, big deal. Does the case lend itself particularly to the UPC procedure as opposed to national procedure? For example, are you in a country where you don't have saisie description and you want it, then the UPC allows you to have it? Then maybe it's a good idea to have your UPC jurisdiction. Same thing for the case law. Of course, we don't have case law yet, but very soon we'll have it. So maybe the case law of the UPC is more favorable to your case than the case law of the national courts. So the real question is, why are some people considering opting out? So one, and I'm not going to say that any of these are good reasons, but just for you to know what the reasons are, weigh them, decide you agree with them, you don't agree with them, you have other reasons. So one reason is it's a new system. Nobody's saying that it's a bad system. It's going to be populated with extremely experienced professionals, the various judges and everybody else around them. But it is a new system with all the uncertainties. So I'm thinking, I've been working for 27 years. I have never not used a conditional with any of my clients. Why? Because I don't have any certainty. When they ask us, how's this litigation going to go in Italy? Well, the first thought I have normally is, I don't know, why are you asking me? But the second thought is, well, it could go this way, could go that way. There is uncertainty always. But this is one concern. Another concern is you may have, and this is something that a colleague of mine made me think about, you may have particularly aggressive competitors. You, as the patent owner, may have particularly aggressive competitors. We have one client who has very nice technology, has a lot of European patents, and the poor client lives basically at our offices the whole time because we have one competitor who opposes every single patent our client gets. So we're very happy because we have a lot of opposition work. The poor client is like, I just got a patent, just leave one patent. Don't oppose it, please. And so the concern of this client, but I think it's a special situation, is I have to face oppositions for every single European patent I get. Now I'm also going to face litigation because the competitor maybe feels like I don't want to litigate in all the countries where the patent is validated. But yes, I'm happy to litigate in one court only, the UPC. So having two proceedings, opposition and UPC, as opposed to one proceeding only. So that's a situation where maybe the client could consider opting out because he's tired of all these proceedings and he knows he'll get the opposition anyway, but at least maybe he won't get the UPC litigation. That's one situation. On the other hand, most of the patents survive, so he could also consider saying, to the competitor, you really want to spend twice the money, if not more, just to find out that my patents are valid anyway. Already granted patents were obtained, and this is more of a philosophical reason, if you like. They were obtained based on the previous litigation system. What I'm saying here is I think of unitary patent and UPC as a trade-off. So just like patents are a trade-off, I tell you my invention, which otherwise I would keep for myself. In return, I have a monopoly for a certain number of years. The unitary patent and the UPC, in a way, are also a trade-off. I have, in the case of a unitary patent, not European patent, a patent that costs less at time of grant in terms of translations. It costs less in terms of renewal fees if I'm really interested in all the countries of the European unitary patent. So I have a bargain there. In return, I accept that the patent could be litigated and potentially revoked, because if it's a good invention, it's not going to be revoked, potentially revoked centrally. I accept this bargain. Those who have already granted European patents, already granted meaning now that the UPC has not even started yet, they weren't part of this bargain. They didn't have the I'd get a cheaper patent protection system end of the bargain. So they could think, okay, so I don't want the other bargain, meaning I didn't have any budget advantages. Unfortunately, I had to validate, I had to translate, I have to pay all the renewal fees in all the countries, lots of money. On the other hand, I got the patent based on the assumption that if somebody wanted to litigate, they would file litigation in many countries. Not everybody wants to do it. I had a certain worldview. So please let me stick with that worldview for my previous patents, and for the future patents, let's go with the future. This could also be an approach. This is the approach that some people are taking. Last thing, and this is particularly true for pharma companies, and I'll explain in a second why, and also some other companies, but particularly pharma companies, has to do with how you view the European market, how your business is organized geographically, and how your budget is organized geographically. What I mean by this is, Pharma companies have to have a local location, a local company in every country where they operate, mostly for liability reasons. You know, if a patient dies because they take a drug, you know, the country has to be able to chase the pharmaceutical company without having to go in India, US, wherever. Hopefully nobody will die, but it happens because of the drug, I'm saying, not because of the disease. So pharmaceutical companies have a physical presence with a physical company with a physical budget in every EU country where they want to sell. So they tend to think, for the time being, still in most cases, at the European market in terms of the market of the individual countries. Yes, they're aware that the European Union exists and they're very happy with it, but in business sense and in budget sense, they still tend to think of it as the budget of the German company, the budget of the Italian company, and so they tend to think of it, of the European system, the current European patent system, as my European company, my German company has a patent, my Italian company has a patent, my French company has a patent. And, you know, when you tell them, but wouldn't you rather, you know, have certainty for the European Union? Either you have the patent or you don't, or at least, you know, for the UPC countries. Either you have the patent or you don't. They will answer, no, I would rather know that at least in some countries I still have the patent, the European patent, even if maybe I lost it in some other countries because there was a litigation in some other countries. So for them, it's not necessarily I don't trust the new court, who knows how they're going to kill all my patents. Not so much. It's more really a business decision of, do I want to lose the monopoly in many countries, for them, it's like saying, do you want to keep the patent in the US and in Brazil and in Argentina, or do you want to lose it in all 3 countries? Why can't I lose it just in the US? It's exactly the same for them, exactly the same. So this is another reason why maybe some companies are a little bit reluctant to join the UPC, and they're considering opting out.
I have no pharmaceutical client where the local guys decide about litigation. I have only, you know, on a higher level, people who decide whether or not to litigate. So I see what you say, but I have no client in the pharma which decides on this basis.
I understand.
It's more what you say is correct. It's more, I'm going to may lose my patent in one proceedings. Yes, that's true. That's a possibility.
Yeah, true. Well, I think it depends on the company, because many of the pharma companies that we work with, yes, when we talk to them, we talk to one person who is in the patent litigation team somewhere on the planet, yeah, and the local company. And we receive instruction from both. And mind you, yes, sometimes the instructions are actually contradictory. Yes. Yeah, yeah. And then we're stuck in the middle. We don't know what to do. Okay. And then they yell us because they say, but the patent people has more important than the local business says, but I'm the local business, and we're stuck there. Don't know what to do. Yeah, maybe, that's in practice. So what to look at when you're deciding whether or not to opt out? First thing that you have to look out is take a picture of Willem, put it in your bathroom. When you brush your teeth, think not opt out. This is what my hairdresser says to me when I cut my own hair. She says, just think of me.
Think about my portrait. Think about my portrait, right?
Exactly. But seriously, think about, you know, the field of technology, not so much in terms of the technology, but how the business is run in that particular field of technology. Think of market dynamics, where are your competitors, where do you have protection, things of this sort. Think of your litigation budget and your litigation familiarity. How much money do you have and how used are you to litigation? And think of your competitors' activities in Europe, and always remember that what your competitor is doing today, maybe in one country, maybe tomorrow they will be doing in many other countries. So think of all the clients, at least we have, who only validate in Germany and then the European patent, and then 3 years later they come and they say, I have an infringer in Italy, what can I do? And we say, nothing. So, yeah, and we told you so. We like to say we told you so. Or any other reason that you may tell us during the Q&A. Thank you very much.